the Angel Network. And so, we understand, the tremendous benefit and support that angel community brings to the startup community here, not only here in Seattle, but across the country. And I've been very active in the National Angel Capital Association over the past 10 to 15 years as well. And we've really seen that asset class evolve, and it's replaced venture capital as the first round of capital going into businesses, as venture capital got a lot more risk averse and looking for more elements of traction before they're willing to fund companies. The angels have really stepped up and become that first outside round of financing. So very supportive of the entire network and group. Janae, maybe you can just say a little bit about your background before we kick off the presentation.
Yeah, so my name is Janae Camacho. I'm an associate at K&L Gates. I'm a first year. Prior to joining K&L Gates, I was an Army veteran who worked in various different industries such as healthcare and a little bit of technology. And I am currently in the M&A practice group working with venture capital and emerging growth companies, as well as doing mergers and acquisitions with Gary.
And I hope you got a screenshot of the partner label so that we can send that on to Pallavi when we're done.
I will definitely do that. I did not, but I will.
Well, good. Well, we'll just jump into it. So the Corporate Transparency Act, you've probably started to hear about this. It's been written about a lot. It has a pretty big impact on angels and the early stage companies, which is why Alliance of Angels wanted us to do a workshop today to give you some basic information to help you understand, what the Corporate Transparency Act does. We are probably going to go about maybe 30 minutes today would be my estimate, and certainly have time for Q&A at the end. And we also welcome any comments or questions along the way. So you can put things in the chat, or you can actually unmute if you want to ask a question. So feel free to do that. But today, what Janae and I are going to do is give you a little bit of background on what the Corporate Transparency Act is, who has to comply with it, what are the timelines, where are some resources that you can find if you have questions about how to interpret some of the provisions, and then also just give you a very recent update. There was a recent court case that took place about a week ago that raised some questions about the Corporate Transparency Act. So it was passed into law as part of a broader National Defense Authorization Act back in 2021. And it's the stated purpose of the Corporate Transparency Act is to get at money laundering through entities that were formed as shell businesses without any identifying individuals, so that whenever there were enforcement provisions, the authorities didn't have any people that they could associate with the entities. So that's what the Corporate Transparency Act is trying to address. There are similar laws and requirements outside of the US already. For example, in the United Kingdom, if you've ever either tried to open a bank account or engage lawyers in the UK, they have to go through very similar type procedures where they get identifying documents from their clients. In this case, however, you're actually filing information with the US government. It's a new body that's called FinCEN, which is a Financial Crimes Enforcement Network, which is a part of the US Treasury, and we'll go through that. But it actually came into effect and started January 1 of this year, 2024. So that's why, you're starting to see a lot of it in the press and people are starting to talk about it. Next slide, please. Okay, who's subject to the reporting? So it's not really a complicated statute, in terms of, there's basically three terms that you need to know, and we'll explain what they are. The first is the Corporate Transparency Act applies to reporting companies, and so there's a definition of what that is. And reporting companies have to disclose information about their beneficial owners, and we'll explain who those people are. And then for newly formed companies, they also have to disclose information about their company applicants. So there's really three basic terms that we're going to go through today: reporting companies, beneficial owners, and company applicants. And then, as I mentioned already, the Financial Crimes Enforcement Network, which we'll refer to as FinCEN, and that's a common term. That's who receives this information, and there's actually an online portal that they've set up where people file this information, and it's a agency within the U.S. Treasury Department. Okay, next slide, please.
All right.
Oh,
sorry, Gary.
That's okay. So what is a reporting company? So the act applies to reporting companies. So it starts with basically a very broad definition where almost everything is a reporting company unless you qualify for an exemption. So any entity that gets formed by filing a document with a state or jurisdiction that you have to create an entity by filing a form. So for example, a corporation, you file a certificate of incorporation. A limited liability company, you file a certificate of formation. Limited partnerships, almost every entity that you can think of that has to file a document with a state to create itself. And so that is a reporting company, unless you hit one of the exemptions. Really, the only thing that folks in the audience might be associated with that wouldn't be a reporting company would be something like a general partnership, which just automatically applies by operation of law, and you don't actually have to form it. But everything else is a reporting company unless you can fit within an exemption. And there are 23 exemptions that are listed in the Corporate Transparency Act. There's one that most companies will eventually qualify for if they survive long enough and grow. And that's referred to as the large operating company exemption. To be eligible to qualify for that exemption, though, you have to satisfy three elements. You have to have a physical operating presence in the United States. So you actually have to have an office location in the US, can't be virtual. You have to have 20 employees or more, and those have to be actual employees, not contractors. And they all have to be employed by the entity. It can't be an affiliate. And then lastly, you also have to have $5 million of gross receipts or revenues that have been reported on your prior year's tax return. And you have to satisfy each of those three elements to satisfy this exemption. So many of the startups and emerging growth companies that apply for funding at Alliance of Angels, or that you may be involved with as a director or an investor, they will be subject to the Corporate Transparency Act. There are a bunch of other exemptions that apply for companies that are regulated in other ways. where their owners are otherwise reported to the federal government. For example, public companies. It's clear who are the owners of a public company, so they're not subject to the Corporate Transparency Act. There are exemptions for pooled investment vehicles and venture capital fund advisors. So if you're part of a large venture capital fund, that would qualify as an exemption. But many of the smaller venture capital funds, and particularly, funds like the Alliance of Angels venture fund, they are not, so they don't qualify for this exemption because they are themselves exempt from registering with the SEC. So in order to satisfy this exemption, the fund or the fund advisor has to be registered with the SEC already. So many of the smaller funds don't have to be registered with the SEC, so they don't qualify for this exemption. So we'll go through an example actually later in the presentation where we talk about companies that have investments through either an SPV or a fund and how that flows through the reporting obligations. There are a few other exemptions that might apply to entities that you may be involved with. Tax exempt entities don't have to report under CTA, but they have to be tax exempt at the time they're created. And a lot of times a nonprofit entity will be formed and then apply for tax exempt status on a federal level. And until they get that tax exempt status, they are subject to the reporting obligations. There are also exemptions for subsidiaries of entities that would be exempt. So if you're a subsidiary of a public company, for example, and it has to be a wholly owned subsidiary, that subsidiary would be exempt. And then companies that are inactive, and there's a definition for what qualifies for being inactive, for having no activities for over some period of time, those entities also don't have to apply. But in general, most small companies, until they hit $5 million in revenues and have 20 employees and a physical operating presence in the United States, will be subject to the Corporate Transparency Act. So that's why, it's a big deal and casts a very broad net. Okay, next slide, please. So the next level of analysis is, who are the beneficial owners? Because the beneficial owners are the people who have to supply their information. And just from a process standpoint, it's the reporting company that has the obligation to file the information with FinCEN, not the individuals. So the reporting company actually has to collect the information from its beneficial owners, and the reporting company must file it with FinCEN. So that will lead to some potential issues, which we'll talk about. But who are the people that need to, that the reporting company needs to report? It's people who are their beneficial owners, and beneficial owners are defined as two categories of people. Anyone who exercises substantial control over an entity, or anyone who controls at least 25% of the ownership interest of the reporting company. And so those concepts, there are some guidance about how to interpret, how to apply those in different situations. But there's also a lot of questions and a lot of gray areas. So that's one of the things that, we've been, consulting with companies over, is how do you interpret these terms? Substantial control, they have a list of people who are, by definition, deemed to have substantial control. And it would be people you would expect: a CEO, a CFO, COO, general counsel. Those are all people who, the CTA lists as people who would have substantial control, and so you would have to report their information as part of the report. But then there's also some kind of general language about, people who have the ability to influence or substantial influence over important decisions. And, what does that mean? That's really sort of broad and vague language. And, it causes lawyers to, really spend a lot of time trying to understand or help guide people as to what that really means. The FinCEN has put out some FAQs and a handbook that go through some examples that are helpful. And at the end of the presentation, we've listed links to those things. They don't go through every example, but one thing that they made clear is just being a member of the board of directors of a reporting company does not give rise to substantial control. There has to be something more than just being a single member of a multi-member board of directors. If you're the board, the sole member of the board, that might be different. But if you're one of three or one of five or one of multiple board members, that alone does not make you a beneficial owner. The other component of this is by virtue of stock ownership, and 25% or more of the ownership interests, they generally look at things. The guidance says you look at things on a fully diluted basis. So assuming the conversion of all options, all convertible securities that are outstanding, to determine whether or not you cross the 25% threshold. But that's another term where there's a lot of sort of ambiguity or room for interpretation. My personal perspective and view of it is, the CTA isn't trying to figure out, who are the owners of venture capital funds, or who are, looking through entities, trying to, determine who controls stockholders, when there are clearly other sort of beneficial owners in the picture, right? So, the CTA is trying to sort of put names behind companies so that they have someone that they can look to in the event that there's some type of enforcement action. So if there are clear beneficial owners, and there are people that are the officers of the company, and there's been compliance with the reporting, I don't think you have to construe these terms too broadly, when you're sort of making these determinations of how to comply, when you have questions about, is 25%, what happens, if I have voting rights associated with my 25%, does that give me substantial control over important decisions? For example, in a typical preferred stock structured deal, you have veto rights or class voting rights over, preferred stock protective provisions. Those arguably could give rise to situations where, there is control over important decisions. But if the company's otherwise got other, beneficial owners who have been reported, I don't think you need to get to that level of detail in terms of, who is a beneficial owner and who's reporting. But those are the sorts of things that we're talking with clients about. And a lot of people are sort of grappling with how to interpret these kind of vague concepts without guidance. And there's been zero sort of enforcement in terms of, there's no guidance in terms of how this is going to be enforced yet. So it's all kind of new in terms of how we're figuring out to apply it in the real life situations. So next slide, please. Okay, so here's an example that we thought would be helpful to illustrate some of the concepts. And Janae is going to sort of walk through and just give you sort of the groundwork of what we're showing here, and then help sort of talk through how this would apply.
Awesome. All right. So we're going to start with the reporting company, and we're going to discuss the type of entity that it is, and it's a corporation that has ownership interest in stocks. They only have about 700,000 in annual revenue. We have two founders. One is a CEO who owns 40% of the stock of the reporting company. We have a founder number 2 who is a COO who has 5% ownership of stock. We have a CFO who has 5% ownership of stock in the reporting company, an equity plan of 15%, and then we have an SPV that owns 35% of stock. These would be considered the direct owners of the reporting company under the CTA. And then through the SPV, we have indirect owners. That would be individual A, who owns 73% of the stock of the SPV, individual B, who owns 10% of the stock of the SPV, and individual C, who owns 5% of the stock of the SPV, and individual D, who owns 12% of the stock. Additionally, individual A directs important decisions through board representation of the reporting company. So when we're looking at this example and we're looking at the requirements under the CTA, we're trying to figure out who has substantial control and who owns 25% or more ownership within the reporting company. So we'll both look at the direct and indirect owners. In this example, founder 1, founder 2, individual A, the CEO, the CFO are considered beneficial owners under the CTA. Founder 1 is the reporting company's CEO and is therefore a senior officer as defined under the substantial control prong of the reporting rule. Additionally, he owns 40% of the stock, which would be over the 25% or more threshold. Founder 2 is the COO of the reporting company. Again, he would have substantial control over that company. Although he does not own 25% or more of the stock in the reporting company, he still would be classified as a beneficial owner under the substantial control prong. Further, the CFO, again, has substantial control over the reporting company and therefore would be considered a beneficial owner, even though he does not have 25% or more ownership of the reporting company stock. And then we look at individual A, who has 73% of the stock of the SPV, and the SPV owns 35%. We do a simple math calculation where we take the stock ownership of the individual A, multiply it by the stock ownership of SPV in the reporting company, and we determine whether or not that meets the 25% or more threshold. In this case, we are at 25%, and therefore he would be considered, or she would be considered, a beneficial owner of the reporting company. Additionally, he or she also has directs important decisions about the reporting company, and therefore under the substantial control prong, he would be or she would be considered a beneficial owner. Individuals B, individual C, individual D are not considered beneficial owners for the reporting company. Why is that? Well, individual B and C and D, they are indirect owners, but based off of their stock ownership of the SPV, they do not own 25% or more of the reporting company. Again, we take that simple math calculation and take the ownership interest of the individual times it by the ownership interest of the SPV to figure out what their ownership interest would be. In this case, individual B would own 3%, individual C would own 1%, and individual D would own 4% of the reporting company. Therefore, they would not have the 25% ownership, and they have no substantial control over the reporting company. Therefore, they would not be beneficial owners. In the event that there is no individual in the SPV that holds 25% or more ownership, there hasn't really been any clear guidance by FinCEN regarding this. And so it's If there are no individuals in the SPV that holds 25% or more of the reporting company, then they would be not be classified as beneficial owners and would not need to report their information. In this case, the SPV would then just be considered to be reported to FinCEN on the reporting company's initial report.
Yeah, so one interesting element here. So all the reporting is with respect to individuals, with this one exception that Janae just outlined. If you have an SPV itself that holds 25% or more, but none of the owners of that SPV, on the flow through calculation would arise to 25%. There is a question in the FAQs that say the SPV itself should report, which again is kind of it. The CTA itself only requires reporting of individuals, not entities. But this is the one exception where they've said they want information about the SPV to be reported. So it's kind of a unique situation, but it also, I think, is likely to be relevant. I think in a lot of the angel-backed companies, could have that type of a situation. So.
Also, I just want to note that the CTA contemplates that there will be at least one beneficial owner identified, either through the substantial control prong or the 25% or more, but there is no cap on the amount of people that could be identified as beneficial owners. And I just want to make sure that you are aware of that.
Yep, good point, Janelle. Okay, let's go to the next slide. Okay, so we mentioned there's also a second category of people that have to be reported. It's called the company applicant. And one point I did not make clear. So the CTA became effective January 1 this year, and it applies to companies newly formed on or after January 1, 2024. But it also applies to reporting companies formed before January 1, 2024. So companies that are already in existence that are a reporting company that don't qualify that for any of the exemptions have to comply with the Corporate Transparency Act. So it's retroactive to those companies. Existing companies before 2024 don't need to comply until the end of this year. So there's a phase-in periods to begin complying. But companies formed beginning 2024 must comply within 90 days of the formation. And newly formed companies have to report their company applicants. Existing companies formed before 2024 don't have to report their company applicants. So who is a company applicant? It's the person who and it's only up to 2 individuals, as opposed to what Janae just said. You could have an unlimited number of beneficial owners, but company applicants is limited to 2 people. It's the individual who directly files the document with the Secretary of State to form the entity, and that could be a lawyer, it could be a third-party service like Single File, or any of the registered agents that file, and a number of those groups are offering services now for CTA compliance, and that can be a good source for compliance. And then there's a second person, is the person who's primarily responsible for directing or controlling such filing. And that can either be the person who executes the document, typically, the person who is the principal informing the entity, or it could be an attorney who puts together all of the corporate documentation. So it's another, group of people that FinCEN is looking for to be able to, follow up, if there's a question about enforcement on the entity and trying to find out who controls the entity. Okay, next slide, please. Okay, so what information needs to be reported? It's fairly straightforward. You have to put your name, birthday, address, and then the big thing is you have to actually upload a picture of either a driver's license, a passport, or some other government issued document, identification document, and those all get uploaded as on the FinCEN website. And again, it's the reporting company that's responsible for doing this, not the individual. So, if you are a beneficial owner or you are identified as beneficial owner for a reporting company, you have to provide this information to the reporting company. Then the reporting company files it with FinCEN. Now, there's an alternative to actually doing that where the individual can go and apply for what's called a FinCEN identification number, a FinCEN identifier, where you can actually get a number. It's, think of it like a social security number where it gets assigned to you. And then you can obtain that as an individual where you put your information in and upload your identification document. And then you only have to supply your FinCEN identifier to the company rather than all your personal information. And so that's a much probably a preferable method for a lot of people if you're having to report across a number of different reporting companies. And then the other thing here is this is not a one-time information requirement. Anytime there's a change to any of this information among any of the beneficial owners, if someone later becomes a beneficial owner, or if someone later drops below, say, the 25% threshold, so you're no longer a beneficial owner, all of that information needs to be, the changes need to be reported with FinCEN within 30 days. So that gives rise to a whole new sort of compliance and reporting regime that companies in the United States have not had to do on a continuous basis. And again, that's where a FinCEN identifier can be very useful in that, especially if you're reporting across a number of different reporting companies, you only have to change your information once on your own individual FinCEN identifier number and not across each reporting company where you're a beneficial owner. Okay, next slide, please, Janae. I already went through the timeline. So, and again, we'll make this deck available for people so you have it as a resource. And then go ahead, next slide, updates. Again, any change has to be reported within 30 days. So if you move, get a new passport issued, whatever, that has to be updated at FinCEN. So, a large compliance element associated with this. Okay, also already went through the FinCEN identifier, the benefits that you get from going that route. Then lastly, just, there are penalties here, both civil and criminal, that, can be accruing fines. So these are things that people need to take seriously. There's also been a lot of questions among clients that we've been talking to about who has access to this information and how safe is it. I'm uploading, first I'm sharing the information with my reporting companies, and then that gets uploaded to some government website. How safe is that? And the question is, it's as safe as any other information that gets filed with the government. It's subject to, potential, leaks and hacks. And, you know, it's also sort of, people have questions about, what is this information going to be used for? And it's who has access to it. And, different government enforcement agencies will have access to it. So FBI, SEC, IRS, all will have access to this information, when they have identified a company that, they're looking at from some type of an enforcement action, so that they have the individuals that they can go after, so that people can't just hide behind shell companies any longer. And so we thought we'd just finish up just talking about, some of the, thoughts about compliance going forward. As I mentioned, this is the first time where there's a reporting obligation that has to be updated continuously anytime there's a change. Most things either update on an annual basis or a quarterly basis in some situations, but it's not, there aren't other sort of analogs where people have to sort of monitor this. So, internally, companies are going to have to designate someone who is responsible for this. Some officer who is going to have to help implement some compliance policy that, has a mechanism for people to report changes, when they have changes in their, in the information that's been reported. And so, some type of compliance policy would be recommended. And the other thing is, companies have the obligation to report, not the individuals, but companies have to have a means for getting this information from their beneficial owners. So that means we'll have to build in some type of mechanism within the investment documents that enable the companies to get the information and require the investors to provide the information to the company so that they can comply with that, and also notify people that there are ongoing reporting obligations to update it, as well as sort of get exceptions to confidentiality obligations. For example, in limited liability company agreements, oftentimes there's confidentiality provisions, so there'll have to be, some type of exceptions built into those provisions that allow the company to report this information with the government under FinCEN. And then lastly, last slide, here are just these, and we'll send these with the actual links that you can access the documents. But the FinCEN registration website now has been open, since the beginning of the year. It's relatively easy and straightforward to navigate. And I say that I'm a lawyer, so it was prepared for non-lawyers, so I think it's relatively intuitive for people to follow. There's also a link here for people to obtain their FinCEN identifier number. And then the FAQs and the handbook that I mentioned, also written for non-lawyers, that also have a lot of, particularly the handbook is made for companies to help them understand how to apply the requirements in a range of different scenarios, different types of entities. And much like we went through the example in our slide, they have a bunch of different examples of how you look at different reporting obligations with different fact scenarios. So those are all useful, I think. And then the last two are pieces that we've put together. The first one is about a page and a half that just goes through a lot of the information here that we went through in this report, but it's in a PDF that you can actually print out and you can read in your leisure. And then lastly, what I mentioned at the outset here, there was a decision that came out of the Alabama District Court on March 1st that held the CTAs unconstitutional. So, that could, put a hold on compliance depending on how that decision works its way through the courts. It's a district court decision, so it's not binding outside of its district. It's the FinCEN has already put out a release saying it's still going to enforce the Corporate Transparency Act against everyone except the people who are the actual plaintiffs in that case. So there's no sort of stay in terms of the applicability of the Corporate Transparency Act, but there are other cases that are pending in other jurisdictions, and it could be if there become multiple cases that reach a similar conclusion, or even if there are sort of conflicting decisions among the circuits, it will go up to through the Court of Appeals, and then it could eventually even go to the U.S. Supreme Court for a decision. But for now, what we're telling people is, for newly formed companies formed in this year, you should still comply with the Corporate Transparency Act. And, we'll obviously monitor, what happens with this decision. For companies that were formed before 2024 that, have until the end of the year to comply, it probably behooves you to wait and see how things shake out with the pending court challenge. Because it could go in a number of different directions. So, I would not necessarily rush to comply if you're, a pre-existing company before 2024. But for new companies, our advice is to continue to comply. And again, the newly formed companies have 90 days until for the initial compliance from the date that the company is formed. And so with that, I think we can open it up to some questions. And, I think there were a few questions in the chat, so we can also address those. Let's see. So one question I'm reading in the chat, it says there are cases where two roles are the same person. That's fine. That same person just reports once, and you have to have at least one beneficial owner that is reported. You can have multiple, but the CTA assumes that there will be at least one person who is reported as a beneficial owner of all reporting companies. And another question here says, is the information included in a single form per company, or is it different for each beneficial owner? It's one form per reporting company, and listing beneficial owners and company applicants all get reported on the same form. And again, it's the reporting company that does that, not the actual individuals who are the beneficial owners.
Okay, I have one question.
Yeah, go ahead.
Okay, imagine a syndicate formed by 7 friends, equal parts. They invest in a startup through a pooled investment company, an LLC. They are gonna get the shares. They're gonna do nothing for the whole year. That means that the only expense is what they file with the Washington State Secretary of State every year, $60, $80, nothing else. And then they do the taxes, and that's it. Question number one, does that qualify for an exemption as an inactive company because there's no revenues, there's no transactions? No.
No, that
Second
would
question.
be a reporting company.
Second question. We have a person who's the one who's filing every year with the Secretary of State, etc. I suppose that is the company applicant, but then no one else has more than 25%. So that means that we would file a form with just the single person, the company applicant, the one who's filing for the filings.
There would have to be some beneficial owner, so
If it's the same as the company applicant.
that could be the same. Yes,
Okay.
that could be fine. Yep.
Perfect. Thank you very much.
Yeah.
Very useful.
Yeah, so it applies to SPVs themselves, that, it could be a reporting company, it's a good example.
Gary, as we get into other entities, in particular estates and trusts who have their own tax ID number, they're of their own entities, how do they fall into this?
Good to see you, Rick.
Likewise. Wish it was a different circumstance.
Yeah, trusts are potentially reporting companies here. And there are some exemptions for trusts, but I think most trusts established for, estate planning purposes will likely, fall under the reporting regime.
Estates?
Estates typically would not be, an entity formed by making a filing. So that would not be a reporting company.
Gary, I think we have another question from Kelly.
Okay, go ahead.
Hi, thanks. Really great information. So I have a hypothetical question. So my understanding from your presentation is that it's based on compliance is based on percentage of ownership versus percentage of voting rights. So there are some companies that have multiple levels of shares, 1 vote per share versus 100 votes per share. So hypothetically, if I own 10% of the company but have 60% of the voting rights, does that mean that I would not have to report?
I think the short answer is if you cross the threshold, either equity or voting 25%, you would be a beneficial owner. Janae,
Okay.
you can feel free to expand on that. I know Janae's been doing a lot of sort of the individual consulting and going through a lot of different fact scenarios. So.
We had something similar that I've worked on, and if you have over the 25% threshold for your voting rights, like Gary mentioned, I would suggest that you would be considered a beneficial owner under the CTA, as well as the fact that having certain voting rights also may, depending on the language within the agreements that you have, provide substantial control over the reporting company. And that's another thing that you would have to look at as well.
Thank you.
You're welcome.
And as I mentioned, there are a number of the filing groups, for example, Single File, who we do a lot of work with, that are also managing CTA compliance or helping companies manage CTA compliance as part of their registered agent and state compliance services. And so they are a great sort of resource for companies. And, for example, I know Single File offers sort of 1 fee annual service for all of the various state filings that they do, for 1 fee, and it includes the CTA compliance. So it's a good alternative.
Yeah, I'm thinking about this FinCEN number a little bit.
Yep.
in a perfect world, and it's in the vein of as the company, can I shed some responsibility for ongoing updates? In a perfect world, if I could get all my investors to go get their own FinCEN number, does that eliminate my responsibility to look after them into the future when they change their driver's license or move or something, meaning those people then have to make their own updates to FinCEN?
I think, you should remind them that they have to do that. You may, as part of a policy, you might want to send out an annual thing to say, please certify you've updated your FinCEN information to the extent necessary.
Okay.
But I think from a compliance standpoint, again, I don't think Treasury is going to go after people for, if they didn't update someone's, address or their passport number. What they're really looking for is to make sure they have individuals that they can, find when, they
Yeah,
have some sort of enforcement proceeding.
yeah. Yeah, you could get into conspiracy theory and government abuse, but that's hopefully not something we need to worry about.
Yeah.
Okay.
Good. Other questions, comments? And again, we'll send around the deck with the links. So hopefully those will all be good resources for people.
It's marginally irritating because, I do work with LLCs. And we go to a lot of pain with the United States Treasury, who is the sponsor here, to fill out tax returns and fill out K-1 forms that have all this information on them.
Yep.
And now they're creating a parallel department that basically wants the same information all over again in a different database.
Yeah.
But whatever.
Along with your picture.
Yeah.
Okay. Thank you, Gary,
Great.
so much.
Great. You're welcome.
Very thorough and knowledgeable. Thank you, everyone, for joining. And enjoy the rest of the day.
All right. Take care, everyone. Feel free to
Thank
follow up if
you.
you have questions.
Thank you, guys. Appreciate it.
Thank you.
Thank you very much.